So, folks, you're watching the Adam Matos trial of Florida. Aaron Keller along with you here at the LawNewz Network. It looks like a sidebar. My guess is that the judge is asking the attorneys what their plans are for the rest of the day, because this is probably a good time for a mid-afternoon break. This might take just a couple of seconds to figure out. Again, this defendant facing 4 first-degree murder charges related to the deaths of his former girlfriend, her new potential romantic interest, according to one account, boyfriend according to another account, and also her 2 parents, Margaret and Gregory Brown. The family had moved to Florida from Pennsylvania not terribly long before the crimes happened, because they were moving to join other family members who were already in Florida. The judge has announced a 15-minute break, and also apparently they're going to go until 6 p.m. today. So they're really going to push testimony a little bit later in the day than we're used to seeing in this case. Thankfully, Norman Williams is here with us, at least for a couple of hours, to help us break down what's going on in the case.
How are you, Aaron?
Pretty good, Norman. How are you?
I'm good. Good to see you.
So always good to see you as well. This has been a case where the defense has been seemingly absent. We had no opening statement from the defense. And with a lot of the witnesses, including the one who just stepped down from the stand, no cross-examination whatsoever. What do you make of the strategy?
Well, not opening is a common defense strategy. If you really don't know what's coming your way, it's kind of a bad idea to get up there and promise a jury anything. I think that there are some competing theories of thought on that issue. Some people feel like you have to say something. So what defense attorneys will do is give what we call a non-opening opening. It just doesn't say much except for pay attention to the evidence and remain fair and impartial. Now, as to not cross-examining witnesses, the rule is if a witness does not hurt your client and there's nothing of good value that you can get out of them on cross-examination, the only thing you can do is make it worse. You can't make it any better. So, you know, when a witness gets up there and an attorney doesn't question them, sometimes the jury goes, oh, okay, that witness meant nothing because the defense doesn't even care. They didn't even ask one question. So that could be the strategy. The other strategy could also be like sometimes, let's say, for example, if you're stuck with the unfortunate reality of having to cross-examine a child witness. Sometimes you just don't want to ask a question because you just can't make it any better. You can only make it worse, and you can only make the jury kind of hate you and hate your client even more. So you stay away.
Well, I can understand the concept behind what's called a non-open open. But in this case, there just wasn't even one of those. There just simply wasn't one.
Right.
And I can't say it, though I've heard that, because normally at a minimum, a defense would say what you said and possibly hammer into this whole concept of reasonable doubt. Now,
Right.
you have to be aware that the state has to prove its case beyond a reasonable doubt. So it's not just he probably did it, or even he more likely than not had done it.
Right.
We didn't even get anything out of this. And part of me is wondering, okay, well, you know, are they possibly going to shift the strategy on the fly based on the strength of the state's case or not?
That could happen. That could happen. They're hoping that something favorable happens during this trial. And it might, you know, it might. Forensic evidence may not bear out what the prosecutor is hoping it will. Things happen. Witnesses' recollections of things get squirrely. I mean, things happen at trial. They do.
Well, you know, it's possible, but look, the bottom line is in Florida, we've got pretrial depositions. So the defense conducted, I think, 100 of them. They know what's going on in this case. So to sort of leave things to the last minute to hope a theory either floats or sinks, it's throwing caution to the wind in a lot of perceptions.
Right. To the person that doesn't do this for a living and doesn't understand the mental gymnastics that goes on, yes, I would agree. It does look like they're throwing caution to the wind. But like you just said, I mean, there's all this pre-trial work that should indicate what the likely outcome is. So I'm quite sure that defense, well, I hope that the defense poured over everything and at least came up with 1 or 2 different scenarios of what a defense could be. I mean, because you want to be able to say something more than this isn't proof beyond a reasonable doubt. You know, that's just, although that's our legal standard to lay people to jurors, that's a sign that the defense has nothing else to say.
Well, in this case, I think the evidence against the defendant looks pretty strong.
Yeah.
Okay, he says not only to the police, but to the local newspaper that he's
Right.
out of there on the date that they believe that the murder happened. His version of things is that I was there, there was this call about a dispute, I got out of there. Okay, well, guess what? Everybody else sees him on the scene for several days after the case. And police are saying, look, that's when you were cleaning up the scene. That's
Right.
when you were using the victim's credit card. That's when you were buying a shovel, which, by the way, we believe is the shovel that we found that was
In the
used
van,
to
right?
try to dispose of the bodies. You're driving around, you know, it's like you're ordering pizza with a credit card. There's evidence of cleanup.
Right.
The bodies get dumped, and you say you're not even there. You're there, and you're telling all the neighbors to bring you to the bank on a holiday when the banks are closed.
Right.
You're telling the neighbors to bring you to get groceries. You got the pizza delivery people placing you there. You've got another neighbor who you're asking to bring you out partying and drinking.
And also the Craigslist customers, right?
You've got the Craigslist customers as well.
Yeah,
Yes.
Yeah, there's a lot. There's a lot that places him there. That's for sure. That is.
It just doesn't. It's not lining up as being a good case for this defendant. This sounds
Right.
like what many people are saying: slam dunk win for the state.
Yeah, it looks like a pretty strong case for the state, but funny things happen at trial.
Oh, I thought you were going to add something to that there.
No, funny things happen at trial. You just don't know. You just don't know.
Well, look, I'm going to be surprised to see where the defense goes in this. My guess
You and me both.
would be that they're going
We'll
to
see.
try possibly to bring in this stuff about this woman in Kansas who had a relationship with the
Leonard,
victim,
right?
you know, and to try to point some third-party liability. But
Right.
I mean, there's enough there to point it, but she's got an alibi. She clocked in at work. People remember her being there at work in Kansas days before, days after, and on the day of the murder. She's got a whole line of time cards and whatnot. So it's impossible for her to have been there. There's no
Right.
airline manifest.
Unless she has a private helicopter and she can zip around.
I doubt it.
Zip around the country.
You know, I don't
at
think
whim.
that she does. But you know, there's enough there to raise some questions about what was going on. But I just don't think it's enough to override the defendant's own presumed lies about not being there and then being there.
No, it's a high hurdle to jump for the defense. That is for sure. And again, like if the best it gets is blaming someone in Kansas for this crime, I mean that's a tough story to sell to the jury.
If I'm to believe the depositions and some of what I was reading between the lines in the depositions, it seems almost as if the defense was going to raise the scepter that there may have been a hitman involved. But then it's like, okay, well, what's the evidence of that?
That's the OJ defense, isn't it? That a hitman.
Well, it's not like we haven't seen
another
other
person
cases in
did it.
Florida that have involved that. We've got
Right.
the DiPolito case that we covered here at LawNewz where there was a hitman hired. Okay, and there was a conviction of that, but we also had stronger evidence that there was a hitman involved. In this case,
Who hired the hitman? Sir?
well, DiPolito, in that case.
Right.
In this case, it would presumably be this woman in Kansas. But then, okay, well,
right.
that doesn't make any sense. Why are all the neighbors placing Adam Matos at the scene when he says he wasn't at the scene? That doesn't make any sense.
Well, because the hitman had on an Adam Matos mask.
I didn't know that they were available freely in the dollar stores in Florida. So,
Hey, Halloween just passed.
well, yeah, but you know, look, it just seems that the state's got a pretty tight case here. So
No, it does. It really does.
we're in the midst of a 15-minute break in trial here. Again, it sounds like testimony is going to run about an hour later than usual at about 6 p.m. today. I want to continue listening to some of the testimony of one of the patrol deputies who was up on the stand earlier, and we'll be back in a few minutes. Sorry about the sound there, folks. Norman and I were just talking about an underlying issue going on here, and that's what's going on with this person in Kansas who the defense at least tried to investigate at one point. The police tried to investigate at another point as a possible third-party suspect. Now, the police were on the record before trial and saying we eliminated this person, and that's pretty obvious because that person didn't face any charges. But here's the deal. There's an unknown female who apparently was harassing Megan Brown, and we know that because Megan Brown, one of the victims who winds up dead, had called police to report some degree of harassment. They didn't think it was credible enough to go on it, so there aren't a lot of records, and they didn't dig into it. They basically told her, look, if it happens again, gather more evidence.
Right.
Okay. Then you've got Nick Leonard, one of the other victims who apparently was interested in Megan Brown, reporting to Verizon that one of the Verizon employees in Wichita is trying to hack into his accounts because he was hacked by someone in Kansas, and he said, look, I live in Florida, there's only one person I know in Kansas, and it's this woman that I've been involved with in the past who works for Verizon. So then they dig into it. Eventually the woman resigns in lieu of being fired. She admits in depositions, yes, I have access to some of his phone records because I pay for them. She's paying for Nick Leonard's phone. She's loaning money to Nick Leonard to deal with the ramifications of a DUI that Nick Leonard had. So they're financially entwined.
Right.
She's got access to the numbers he calls. She claims she doesn't really do anything with them, but it raises some questions about what's actually going on here. Now, right before these folks wind up dead, within a few days, is when Nick Leonard calls Verizon and lodges the complaint against this woman. And she had just been in Florida on vacation shortly before the murders happened. And while she was there, she's like, oh, I didn't have any contact with him because I knew he was involved with somebody else at that point. But I did drive past the house and see his vehicle outside the Brown residence.
Right.
Okay, and then I was in a restaurant and I saw him coming out, but I didn't talk to him. And it's like, well, if they had no contact, how are you showing up in all these places where he is?
Well, also, how do you show up at the Brown residence when you don't know them and don't know where they live, and he does not live there?
I know, it's weird. I mean, do they live on a main road where she happens to see the vehicle? Is she tracking the cell phone? There are all these what ifs.
That's
and
right.
I'd say in a normal case, you tell me if you agree or disagree. In a normal case, this would be pretty strong third-party liability evidence. In this case, I think it still falls flat.
I'll tell you what messes it up. I think that the phone activity, the popping up at the right places, that stuff is good for the defense. What isn't good is that if she were to hire a professional person to kill Leonard, it just wouldn't have been so messy. It wouldn't have happened at someone else's house. They would have caught him by his house or traveling someplace that he goes on a regular basis, let's say work or to the gym. It just would have been very clean. You know, it wouldn't have been messy. It wouldn't have been bodies everywhere the way that it is when it's personal in nature as opposed to professional and work in nature. So for her, if she did the hands-on killing, then maybe, but there's no evidence of that. And if she would have hired someone, then the killing would have been much cleaner, and Megan and her mom and dad would probably still be alive. Only Leonard would be gone.
I agree with that assessment as well. We're going to jump into another clip here, but before we get there, we were just playing some older recordings of this particular defendant, and I'm sure many of you noticed, just look at the difference in the look versus some of those initial hearings. He's unshaven versus what we're seeing now. It's always interesting to see the way defendants transform and the way they appear at trial. So we're going to listen to a little bit different testimony now from earlier in the case. We're going to jump into Deputy Thomas Smith. He was one of the patrol deputies.
To focus your attention back to September of 2014. At that time, were you a patrol deputy with the Sheriff's Office?
I was.
All right. I'd like to focus your attention on a specific day, September the 3rd of 2014. On that day, did you receive information that you were to be doing a welfare check?
Yes.
And do you recall the particular address that you were going to be doing the welfare check at?
Not the specific address. I remember the house, though.
You remember, you can see it in your mind?
Yes.
All right. When you are given a call to respond to a particular location, is there a record that is generated that would indicate a call for service?
Yes, it's an event.
Okay, an event. And that's something that's noted by the sheriff's office,
Yes.
and sometimes referred to as a CAD report.
Yes.
In that CAD report would indicate address,
Yes.
times,
Yep.
and deputies that would respond.
Correct.
All right. Deputy Smith, if you were to see a CAD report or an event report, would that help refresh your memory as to the particular address that you arrived to?
Sure, yes.
All right. Your Honor, may I approach?
You may.
Just for the record, Judge, I've shown this to defense counsel. Deputy Smith, take a second, look at this event record. Right, you see the fact that you are mentioned in this event record.
Yes.
All right. Does that event record correspond with the date that I mentioned, 9/3 of 2014?
Yes.
What address did you respond to for a welfare check?
12721 Woodchuck Way.
All right. And responding to that particular address would have been in reference to a call for a welfare check, correct?
Yes.
And you mentioned earlier that you can see in your mind the house that we're talking about, the place that we're
Correct.
talking
Yes.
about. Did you in fact go to the door and knock on it?
Yes.
Did you announce yourself as a sheriff's office?
Not at that time.
All right. Did you look around the residence to see if there was anything suspicious or anything particular of note?
Yes.
Did you see anything suspicious?
No.
All right. Was there a neighbor that was outside of the residence?
Yes.
Without telling me what he said, did you have a conversation with him?
Yes.
All right. Could you see whether or not there was a vehicle in the particular spot associated with that
I
residence?
could see.
Was there a vehicle there or not?
No vehicle.
All right. Did you, as accordance to the report or the event report, close out and move on and make note of what you saw?
Yes.
All right. I'd now like to go forward one day in time to September the 4th of 2014, okay? You were working that day as a patrol deputy?
Yes.
Was there a particular area of the county that you were patrolling?
Yes.
And where was that?
North of 52 from the water, pretty much out to like Shady Hills Road.
All right.
Pretty large area.
It is. But you're familiar with that area?
Yes.
And did you receive a call to back up or participate in another welfare check, but this time with Deputy Silva, who had already been on scene?
Yes.
Did you arrive at 7719 Hatteras Drive?
Yes.
Are you familiar with that area?
Yes.
Okay. That's near the intersection of Old Dixie Highway and Hatteras?
Mm-hmm.
Is that a residential area?
Yes.
All right. When you arrive, do you have a conversation with Deputy Silva?
Yes.
Does he kind of inform you about the things that which he's seen and saw?
Yes.
Paying particular note to a closed garage door. You know what I'm referring?
Correct.
Was there a window missing?
Yes.
All right. Were you able to approach that window?
Yes.
When you approached that window, what did you notice?
I noticed there were vehicles inside the garage, and I noticed an overwhelming smell
Okay.
coming out the window
And how would you describe that smell?
as decomposition.
All right. Again, you mentioned that you've been a deputy for 9 years. During your time as a deputy, had you had the opportunity to participate in investigations where people may have been deceased?
Yes.
Have you come across scenes or participated in investigations where a body may have been outside for a particular amount of time?
Yes, or inside.
Or inside, okay. Through your time as a deputy, are you familiar with the smell?
Yes.
How would you describe the smell?
Overwhelmingly pungent.
Okay. But as a characteristic of the smell, is it a unique smell?
Yes.
All right. And when you smelled it that day on September the 4th of 2014, how quickly were you able to discern that that smell was in fact decomposition?
Immediately.
All right. And I saw you walk in here. You're how tall?
6'3".
Okay. So you were able to get pretty close to the window,
Yes.
or missing window. Mm-hmm. And as you got closer, did the smell get stronger?
Yes.
All right. Did you and Deputy Silva decide to make entry into the residence?
We did.
All right. I'd like to focus. Well, is it working? Nope. Okay. The projector is not working. I'm going to show you what's been marked as State's Exhibit 25. Okay. You recognize that photograph?
Yes.
Okay. I'll hold it.
It's in evidence. You can step down if you want.
Come on, step down with me, Jack.
So much for big TVs.
Yep.
Oh, do we get it?
Don't.
All right, we'll move on. It's
All right,
fine.
no
Okay,
problem.
we'll have all weekend to fix
We're
it.
good. I'll show the photograph first.
They've seen it, I think.
All right.
Yes.
Okay. Deputy Smith, forgive me. When you arrived, was this garage door open?
About 3 inches at the bottom.
Okay. And were you able to because it was open, what did you decide to do?
Well, that was the door we ultimately lifted up because we knew it wasn't latched, being up about 3 inches.
Okay.
Went around the house first,
All right.
looking for a regular door.
But you went in this garage. When you made entry into the house, you made it through this door.
Yes.
So that was testimony from earlier on in the trial. It looks like they might be bringing the jury back into the courtroom, but we're not exactly sure. So we're trying to see how quickly we can bring back to the case. The judge called a 15-minute break about 20 minutes ago, so we're certainly ripe to have the feed back up, but right now we're looking at these wires, as you can see. So Norman Williams is still along with me here, attorney in New York City. Here's what we've got. We've got the defendant calling a couple of the victims 200 times between 6:11 in the morning and 8 in the morning on the 28th. Most of the calls are to Megan, but a couple of them, or some of them, were to Margaret Brown. 200 times. That's what investigators said in the depositions.
A bit obsessive.
Well,
Something's
it's also
going on.
right after the domestic violence report from that morning.
Yeah, something's going on.
So you know something's up from that. Now, he makes his last phone call to Megan at 4:12 p.m. Now, that's kind of interesting because the wife had gone to work at 3 o'clock.
Right.
So might it be that these crimes all happened late in the evening? It would seem that way because we also know that Greg had gone to the store to get some parts for the RV that he was working on. But 4:12 p.m. was the last time the defendant called Megan, and no communication after that point.
Right.
And then he winds up getting caught by police several days later in a hotel, claims that he left the place after that point. You know, it doesn't line up because he makes the last call at that point. Would he presumably not be calling the family that he was living with and the mother of the child after 4:12 p.m. on the 28th, even if he was leaving town?
Right, yeah.
He had the kid.
It's just weird.
He had the kid.
Yeah, it just doesn't work. No matter how you
Doesn't
slice
line
it.
up.
No matter how you slice it, it just doesn't. It's true.
I don't see it that way either. I mean, it is a very bad case for this particular defendant. You know, he gets spotted by neighbors at the murder scene at 12:35 on the 29th, and they say that he's sweaty and out of breath or something like that.
Right.
It's clear something's up. And he's trying to play cool with everybody and ask him what's going on, and this must be your family, and this, that, and the other thing. So after midnight, the 29th, he later tells police, later tells the local newspaper he'd been out of there at that point, but yet they spot him.
Right.
They spot him more than 12 hours after he's said to have left the scene. He's there when the Craigslisters start to show up on the 29th, and there are multiple people from Craigslist. So they spot him on the 29th at multiple times, 2 p.m., 4:15 p.m. There's another time that I don't even have plugged in.
4:30.
4:30, he's there then, and there's yet another group of them that show up, I think, either shortly before or shortly after the 2 p.m. people. So this is on the 29th. He's there almost all day on the 29th. Then he gets a pizza delivered, okay, the
Right.
first of several, and the pizza delivery people spot him there.
Right.
And then he drives the family van to Walmart at 11:30 at night on the 29th and buys a shovel. Well, now later, they find the van loaded with blood, body fluids, and maggots. It's just disgusting. And he's driving around in the van. And they catch him on the, he's at Walmart, bottom line. They know that that's what's going on.
Right.
So you've got a timeline. He's there at least 36 hours after he said that he had left.
Right. Right. Besides the fact that he's on his phone to contact people. So I'm sure that if the prosecution wants to make their job a little bit easier in terms of getting a conviction, would present some historical cell site information, which will show that he was using the phone and he was actively in the area.
It looks like we're just about to head back into court for live testimony here. The judge is back on the bench talking to jurors, so we're going to go right straight